Okay, I think we can get started. It's 11 o'clock. So thanks so much and for joining us, and welcome to this Financial Inclusion Week webinar on data paradigms beyond consent. I'm Alex Rizzi, a Senior Director at the Center for Financial Inclusion, and I'm delighted to host our guest, David Medine, for this hour-long session. Just briefly, just wanted to put this slide up in case, just to remind folks how to connect via audio. We've seen a few participants have some issues. And since this is the third day of Feed Loop, I'm sure you all are quite familiar with the format, but we would just encourage you to please use the chat function on the right side of the screen, post your questions. There'll be a section in this session for David to answer questions. So we hope you'll share your thoughts and comments. And David and I also wanted to combat Zoom fatigue by making this session interactive. So we're trying something a little different. We have a couple of questions we'll be asking you throughout the webinar. And some of those questions will help determine what David focuses on, sort of like a choose your own adventure format. And we're not going to have quite so many permutations of options, choose your own options, as some of the books that this inspired this approach. But we wanted to let participant interest guide our presentation. And as CFI thinks about its future work on data and financial inclusion, one of the looming questions for us has been how to approach the idea of consent in a digital age. This topic has implications for all of us when we think about what exactly we're consenting to when we sign up for data-driven products and services. I read recently about a service called unenroll.me, which was framed as a simple, automated, unsubscribe service for your email inbox. But while Unroll.me was providing this service to subscribers, they were also selling aggregated data to Uber about Uber's competitor Lyft by looking through the Lyft receipts that were in their users' inboxes. And we're also probably all aware that many of our apps on our phones use our location data to send us customized advertisements. But are we also aware that further on the value chain, a hedge fund might buy up that geolocation data to analyze which retail stores we go to? So there's just more types of data, more players, more complex value chains, more monetization of that data going on. And it's really hard to keep track. And this is complicated even further by people's stated desire for privacy, but the unlikelihood of them reading privacy policies in full, or their willingness to trade away information or data about themselves for customized products and services. And in one study that David told me about, their willingness to share their friends' private information in exchange for pizza. So stated preferences on privacy and behavior, there is a bit of a mismatch. And when we think about the implications of all of this and the data ecosystem for financial inclusion and low income consumers, there definitely are lots of questions about the efficacy of a consent-based paradigm for data sharing. And so so before we kick things off, before David jumps in, we'd love to get a pulse of the room on how they feel about the utility of consent. And so we're starting off with a poll, and you can click engage and tell us how you feel, if you feel consent is an effective way to give people control over how their data is being used. And maybe we've primed you a little bit for an answer, but let's see. Okay, we've got about 2/3 no, a third yes, a little bit more with yes. So holding steady at I think 2/3 no. And I think we definitely primed you a little bit, but interesting to see there is a mix that some people also feel it is a useful paradigm. So so I'm just so delighted that that David could join us today to talk more about consent and some of his work on thinking about paradigms beyond that. David's a senior consultant at CGAP and was previously CGAP's staff lead on data protection and security. And his work there has been focused on developing consumer-oriented approaches to data protection and to encourage cybersecurity resource centers. One of my favorite papers of 2020 was written by David and Gayatri, which talked about a lot, his colleague Gayatri, about a lot of these issues. I think it was only published in January, but just with everything going on this year, it feels like it was, I don't know, a few years ago, but would highly recommend reading it. And we can certainly link to it on FeedLoop. And David has more than 25 years of experience on privacy and consumer financial services that range from the SEC to the Consumer Financial Protection Bureau to the White House Economic Council, the Federal Trade Commission, and private legal practice. So we're just thrilled that you will be sharing your work and insights with us. And I think I'll just turn it over to you.
Great, thanks, Alex, and thanks to CFI Axion for inviting me to participate. The head of Sun Microsystems many years ago said, "Privacy is dead, get over it." I'm not sure we're quite ready to say consent is dead, but I think based on the poll results, maybe it's on life support, and we need to think about alternatives. So starting for why I and CGAP have been involved in this issue is financial inclusion, as I don't have to tell people on this call, requires trust and confidence. But I think an important component of that is trusting and having confidence that your data will be handled properly. We've done some other work recently at CGAP that shows a strong interest among poor people for protecting their financial data. In fact, above 60% of people that we tested in Kenya and India were willing to pay more for a loan product or financial service if their data was protected. And we even had half people during the pandemic were willing to pay more to protect their data. So there's clearly a strong view among poor people about the importance of data protection, and which is why many countries have adopted data protection legislation. And for those who haven't, the time is now. But consent, as I think we've indicated, it doesn't seem to be the way to go. And it's a bit of a challenge because consent has been integral to the approach to data protection since the 1980s and on forward. The OECD, the US, the EU have largely based their models of data protection on tell someone what you're going to do with their data and give them a chance to consent or not consent to that. And we'll talk in a minute as to why that approach doesn't work. And instead, why the paper that Alex that you mentioned proposes a number of alternatives to consent or going beyond consent. In addition, if we have time permitting, there are some other important rights that should be given to consumers, even though consent may be fading away as a significant one. If you want the next slide. So why is data protection important? I think we're dealing with vulnerable populations, minorities, low income, remote residents, who may have limited access to internet and even telephone services. So try to give a privacy notice on a feature phone could be a day-long download exercise. And so that's clearly not going to be very helpful. We have, again, literacy challenges, technological sophistication challenges, but at the same time, more and more companies are gathering huge amounts of data about what we do, who we are, how we spend our money, and making decisions based on that data. So data has become increasingly important in our lives, but in some ways we're losing control over how that data is used. Of particular importance is the automated decision-making and machine learning, artificial intelligence, which offer great opportunities for poor people in taking into account alternative forms of data but there are also risks, for instance, of using social media data where you may be discriminating against people in a particular group rather than giving them individual consideration. So how people's data is used, I think is ever more important, and to make sure it's done in a fair and reasonable way. Next. So the question is, why doesn't consent work? And I want to outline a number of reasons, starting with those who have smartphones. It's not uncommon for people to have from 5 to over 200 apps on their phone. Some studies have shown that in the US, people have an average of 80 apps on their phone. I would stop right here and ask, I guess we're not going to poll this, but ask people in the audience to at least virtually raise their hand if they've ever read a privacy notice for an app on their phone. I think the only time I've ever gotten hands raised were a bunch of lawyers in the room who were hired to write those privacy notices. But I suspect that few, if any, people have actually read those privacy notices. I'm certainly in that category. And yet those are critical in determining how the information about you is used and collected online. Someone did a survey of app privacy notices and found that on average, they authorize third-party sharing of your information and up to 3 entities that the information is shared with. So if you take an average user having 80 apps on their phone, many have more, times 3 for each one sharing to a third party, you've essentially agreed to having 240 parties get access to your data, and you have no idea who they are or what they're likely to do with your data. Again, not to mention the fact that apps collect collection data, contacts, things of that sort. So it's very, very hard to keep up with privacy notices. And it's not, of course, not just apps that have privacy notices. We have the websites that we constantly visit. And increasingly, we have Internet of Things devices in our homes, security alarms, cameras, motion detectors, smart light bulbs, smart refrigerators, and so forth, that are all collecting lots and lots of information about people. And people generally don't understand how that information is being used. Some surveys have been done as to how many people read privacy notices. Again, I didn't see the virtual response to my suggestion, but I suspect few, if any. It's usually an impediment to try to get to whatever you want to do, say on the internet or with your smartphone, so no one takes time to read the notices. Carnegie Mellon did some work a few years ago to try to figure out if you took the average number of privacy notices people confront in their lives, how long it would take to read all those privacy notices. And I think they came up with about 6 weeks of your year would be spent just reading privacy notices. So clearly we've become inundated. And I think that is a change from 20 or 30 years ago when the consent model was being developed, that now we're just overwhelmed with choices and we don't want to make them. The NIPFP, which is the National Institute of Public Finance and Policy in India, did an interesting study last year where they recruited college students and law students and gave them privacy notices to read, and then asked them a series of questions about the privacy notices. So we start off with the people who are relatively educated, being tested, and these were open book exams. They were allowed to look at the privacy notices and answer the questions, again, which is more attention than most people pay to privacy notices. And still, half or more missed basic questions about how information was being used based on what was put in the privacy notice. So even, again, a well-educated group have understandably challenges in interpreting the impact of privacy notices. So again, I think it's shifting the burden to individuals and consumers to manage their data is really unfair. One is, again, as I've said, they're inundated with too many choices. The privacy notices, and I'll have to plead guilty here, in one of my prior lies, I worked at a law firm drafting such notices, but they're often written in legalese. They're often drafted to give companies the broadest possible use of your data. Sometimes the choices that are offered are binary, which is you can have basically almost, you can have the service or not, and you can't essentially negotiate the privacy terms. You have to accept whatever you're being offered with maybe a few choices here and there. and as I mentioned before, there's literacy, technology challenges, and a lot of people without smartphones, and also even the languages. Obviously, there are many countries that we all work in with a multitude of languages, and sometimes the privacy notice is written in English, which may exclude large parts of the population from even understanding what's going on. So I think the system right now is designed in a way that it doesn't work, it doesn't facilitate intelligent decisions about how data is being used, and yet at the same time, data is being used in very significant ways that affect people's lives. So again, I want to talk about where consent might work and consent doesn't work, mostly on the doesn't work side. Again, use of information. After information is collected, what's critical is how does the entity who collects the information using the information? Is it used for your benefit? Is it used for their benefit? Is it used for what kinds of purposes? Consent really is ineffective for that. As I mentioned before, disclosures to third parties, which by the way, in the survey work we've done in India and Kenya, third-party disclosures was the most troubling to consumers. We did a project in Kenya where we gave people an app and offered each week to buy back some of their privacy protections. And the one protection people were least willing to sell back to us in this test was disclosure to third parties. They did not want their data to be out there and potentially used in ways that were not favorable. And so that consent doesn't work very well there. How long information is collected. People basically probably don't know or understand how long their data will be kept. And the longer it's kept, the more vulnerable it is to hacking or misuse. And again, how security is what kinds of security protections are in place. Consent can play a role in your determining what information you provide to a provider. I mean, you generally know what you're providing. Although even that I think is changing as people, apps study where you are. You may not appreciate fully all the information that's being collected about you. So even in that limited regard, consent doesn't work very well. India, I think, has an interesting approach of a digital locker where you can store your information and approve or deny access to it. I think that's certainly a promising approach to put consumers in charge of their own data. So there are three paradigm choices, not necessarily mutually exclusive, but that we've suggested. One is a legitimate purposes test, which is specifying how data will be used. Another is a fiduciary duty approach, which focuses on the interests of the customer. And then the third is a privacy representative who can help people out. And I think maybe I'll turn it back to Alex if we want to vote on what comes next.
Okay, so we're going to try this out. So we wanted to hear which of those three paradigms that that David mentioned, kind of beyond consent, you'd like to learn more about. So if you click the engage and vote, legitimate data use restrictions, data fiduciary, or data intermediary. Oh wow. Oh, it was tied. And I at first. Okay. I'll just give it another second. It seems like or I'll give it someone needs to break the tie. Okay. Legitimate data use restrictions, I think, is number one, then data intermediary, then data fiduciary. So why don't we start with legitimate purposes standard, since that's where the group went. And so you can all click back to stream now to see the slide. Thanks for choosing your own. Thank you for participating in that. Okay, back to you, David.
Okay, great. Thanks for your voting. So legitimate purposes is a test that I think some of you may have just heard Malvika Bhargavan speak in the previous session, but she and I once brainstormed about what do we do to fix consent. It's easy to bash consent. It wasn't so easy to come up with a solution, but what we came up with this concept of a legitimate purpose test, which basically takes the approach of looking at a provider and saying they can only use the data they collect essentially for the purposes for which the data was collected and for no other purpose. And so The one example might be if Amazon collects information, wants to ship you something, they don't need to know your religion or your previous financial history necessarily if you're paying with a credit card. They just need to know essentially what you've bought and to deliver it to the right address. By the same token, you may have a situation where consumers are being provided wide-ranging financial advice, and it may be very important for them to know your whole range of financial transactions, your debts, your credit limits, and what money payment services you use. I mean, a wide variety of things to provide you appropriate financial advice, which would justify collecting more data and using it in ways that are relevant to the service that's being provided. So we think that this is a flexible approach that really each business essentially can write the terms of its data usage depending on the products or services that the business offers. That's not to say that this is a test of each individual would have a different standard. I think there would be a common standard across the business so it would be manageable. And I think you would look to the reasonable expectations of the consumer in setting what types of uses would be expected by the consumer and therefore allowed. But again, I think the critical thing here is that the burden is put on the provider to limit use, and the burden is not put on the consumer who is least able to govern how their data is being used. In some ways, one of the analogies we would use is in daily life, if you go into a restaurant, you don't have to sort of go in the kitchen to see how your food is being prepared, if it's meeting proper health and safety standards. That's essentially the government's job, is to impose those on the provider, in that case, the restaurant, to make sure that your food is handled properly. And likewise, it shouldn't be the consumer's burden to go behind these mega companies to figure out what they're doing with your data. Consumers should have an understanding based on law that their data will only be used in ways that are legitimate. And I don't want to stop there because the legitimate purposes limitation, I think, is one thing that's significant protecting consumers. But I think also, particularly in the financial inclusion environment that we operate in, we do want to give companies a chance to use your data to develop new products and services or refine existing products that benefit the consumer. So we don't want to hinder that. So the question is, how can we balance that important consideration of innovation with protecting consumers? And our thought on that regard is to allow a business to de-identify, aggregate, anonymize individual data so that the business could use the data to develop products. And it doesn't need to know who these individuals are. It just needs to know something about them in terms of designing its services, but that it could then therefore essentially be a win-win, which is the consumer has limited use of their personal data to what they expect, but the business would have a broader use of your data so long as it wasn't in individually identifiable form. Now, one response can be, of course, it's very easy to re-identify data these days, and there have been lots of interesting tests that have been done of that. Netflix once put out, hundreds of millions of people's choices on Netflix, and to try to incentivize people to come up with a better algorithm for predicting what people will want to see next on Netflix. And some very clever computer scientists went back and figured out, even though anonymized, who the people's rental history was based on their postings on Facebook or other social media. There's also been people who've re-identified health records. The question is, why do we feel comfortable calling for de-identification in this context? And I think the answer is that I think there could be contractual or legal restrictions against re-identification that could be imposed on providers. So they can not only can they de-identify it, but they can't re-identify it. And even one example of how this might be done in India, there's pending data protection legislation, and the one criminal provision in that law is against re-identification. So I think with some important teeth, we could essentially have both sides have a win-win and not really allow the unlimited use of data right now that consumers can't really control. So there's a question.
We could, I'm just posting. Yeah, okay. We can do that later.
Okay.
Yeah.
Anyway, so I think that overall is a legitimate purposes approach.
I think we're good on time. I think we could do maybe the second choice was data fiduciary as well.
Sure. Sure. So data fiduciary is a concept that has been kicking around for a while. A Yale law professor, Belkin, has proposed it. And basically, a data fiduciary standard is that companies should use data in ways that benefit their customers. And so, not essentially put their customers first. And there are other examples outside of the data protection context where the fiduciary approach is used. For instance, financial advisors have a fiduciary relationship with their customers. So if you have a financial advisor, and it might benefit the advisor for you to buy and sell stock all the time because that runs up transaction costs and fees for the advisor, that the advisor should not be recommending that if it's actually better for you to buy and hold stock or other investments, because that serves your interests. So essentially there's a requirement in a fiduciary relationship that the fiduciary put the customer's interests first over their own. And so in putting this in the data context, the question would be with a merchant or a financial service provider is what would benefit my customers most and how the data is used, and that's what I'm going to do. Now, some people have raised concerns about whether this creates conflicts between a provider and its consumers. Again, I'm mentioning that the provider doesn't maximize their income necessarily, but maximizes the benefit of consumers and how the data is being used. And some people have even gone a step further and to say that providers would violate their duty to their stockholders because stockholders expect the company to maximize its income. And if providers are acting in ways that don't maximize the company's income, but maximize the benefit to the consumer, then they're violating their duty to their investors. And it seems to me that is sort of a simple problem to overcome because you simply change the law of duties to stockholders and say the duty is for the company to behave responsibly and for the benefit of consumers. And I think many could argue that in the long run, that's actually better for the company anyway. We've certainly seen lots of examples of companies whose reputation has been harmed by misuse of data, and in the long run doesn't help a company. I think we've even seen some examples how Facebook has been challenged by some of its past Ds with regard to Cambridge Analytica, and maybe it would have been better in the long run to make sure people's data had been handled properly. And so I think these are sort of false arguments as to why companies should not apply the fiduciary standard in providing and limiting the use of customers' data. Do you want to go on to the third or move on?
Yeah, I think we're doing great on time. I think we can cover all the,
the options. All right, so everyone, regardless of your votes, we can discuss all these things. Yes. So the third is called a privacy representative. And this I think really can be in addition to the fiduciary duty and the legitimate purposes approach, which is that to try to encourage the creation of privacy representatives. And these could be individuals who are hired, these could be government agencies, they could be private-public partnerships, but it could be someone out there essentially who's acting on behalf of the consumer, advising the consumer. I think one area that is troubling a lot of people right now are use of algorithms because they're black boxes. Nobody knows what's going on with the algorithm, and yet the algorithm sometimes can be biased in what its determinations are. And consumers don't really have the right or the ability even to look at those algorithms and see if they're operating properly. But there could be privacy representatives whose job it was to check out algorithms, and if they could, as an initial matter, see if the algorithm was acting in a biased way, and if it was, sort of get further and further access to what the algorithm is, how it works, how it was taught to behave, and then ultimately require that the users of the algorithm either not use it or adapt it to be less biased, but essentially someone who could monitor or police the use of algorithms. And then with regard to privacy notices, as we've been mentioning, they're largely inscrutable by most people, is you could have a privacy representative whose job it was to read the notices, understand them, maybe even warn people about practices that are troublesome. And one analogy here would be the patient-doctor drug company relationship, which is patients have a challenge understanding which drugs they should be using, the side effects, the benefits, and so forth. And their doctor is really their representative as an intermediary between the patient and the drug company to educate the patient about what the drugs will do for them and how they will benefit them or harm them. And so similarly, the privacy representative could sit between the individual and the website or the app provider to say, here's the privacy notice, stay away, or here's one that seems like a reasonable approach. So privacy representatives, again, could serve a number of roles. And again, they could be paid, they could be a government agency. Consumer Reports in the United States, I think, has set up a privacy lab, which tests what information is being collected and how it's being used on products and services. So it could take any number of forms, but essentially empower consumers to protect themselves better in this sort of environment where it's really hard to know what's happening with your data.
Right.
Do you want to go on to this?
Yeah, sure. And
Okay.
then I think maybe before we go on to the next poll, there were a couple of questions that I think would just on the different frameworks too, but maybe,
Okay.
yeah, do this.
Sure. And so I think sort of going hand in hand with limiting or disposing of consent as a way of protection. And again, I think it's largely because look at the cookie notices we see on websites. I don't know if anyone wants to raise their hand in the audience as to how many have read one of those cookie notices, but mostly we click through them to get to the website. So on the upfront side, what we're really trying to do is get what we want out of the service or product or app. But on the back end, it's important that consumers have rights, and I think that's a time when actually consumers exercise their rights. And so here are some rights that Gayatri and I wrote the paper back earlier this year, which, as you said, seems like an eternity. These are some of the rights that we outlined. They may not be the exclusive list, but I think they're important rights to give consumers, and so that consumers can exercise them at a time that's meaningful for the consumer. So the first, which one is I think is critical, is access and correction. You should be entitled to accessing information about you that's being held by a provider. And that's particularly important where the information is being used to make decisions about you. Certainly credit bureaus are a classic example of that, but there are many other contexts in which information is collected, and it's important that we know that the information is accurate, timely, complete, and if it's not, that we have the ability to dispute that and have an investigation and correction of the information to make sure it's, again, serving our purpose as well. Even on ad profiling, people who don't mind getting ads may still feel that they're not profiled appropriately or want to change their profile, and they ought to be able to even fine-tune that as well. Portability, I think, is an important right that is found in the GDPR, but it's also reflected in open banking laws, which is I should have a right to take my data from one provider and shift it to another. And in the financial context, that can be really critical to encourage new entrants into a marketplace. So maybe everyone is using a money transfer service and a new one wants to start up. If customers can transfer their payment history to the new provider, or if it's a bank to a new bank, that would ease the ability of new firms to enter the market and provide competition, better services than the incumbent firms. And so portability, again, is a powerful right. Both that you have access to your data yourself, but you can move the data around. And India has proposed an account aggregator concept, which would essentially put firms in the middle between financial institutions and customers, again, to allow data to easily be moved around. Retention limits, as I mentioned earlier, is an important one, which is data should be kept you should only collect as much data as you need, which is a data minimization concept, and only keep it for as long as you need it. The longer data sits around, the more prone it is to being hacked and causing injury to people. And so it's better that data retention be limited to some reasonable period of time. Again, there may be legal, tax, accounting reasons to keep the data, But once those are passed, then there's no reason to keep the data on hand. Objection to information uses. Obviously, I should be able to opt out of marketing, but there may be other troublesome uses of information as well. Much more controversial is the right to be forgotten, which is found in the GDPR, which limits Google's ability to direct searches to particular websites if people are troubled by the information there. But in general, it's important that consumers be given a broad range of rights as to how their information is being used. Breach notification is a concept that started actually in the US. The EU takes the lead on a lot of data protection matters, but breach notification really got its start here and in California, which is not unusual, where the state required it and then it spread throughout the entire United States. Which is that if a company has suffered a security breach and your information has been compromised, you have a right to notification of that. And in many cases, that also includes free credit monitoring services, access to your credit reports, to see if the breach, if your information was misused in ways that caused, that resulted in identity theft. One area that I think could be modified in breach notification, I think it's something worth considering, is not only notifying the affected consumer, but having a public registry of breaches as well. This is done in the environmental context, which is really to hold companies responsible for their environmental spills. And it's been suggested this would be an appropriate change in the breach notification context, so that not only do customers know what's happened, but potential customers could refer to a breach registry to see if it's a company that they want to do business with, which could put more pressure on companies to handle their data properly and employ appropriate security measures. So I think that's something that may see some action. The EU has now gone on to breach notification as well, but that is a concept that started in the US. Limits on automated decision-making and profiling. Again, one suggestion that the EU has adopted is having a human element to automated decision-making. So there may be obvious mistakes that the computer didn't realize were mistakes, compelling circumstances, such as we're in now with the pandemic, that would suggest that you want to override the automated decision-making. There are some risks that human element could impose bias into the process, but I think by and large, there's a feeling that it's important to not have the machine make the final say about what happens to you. And the last is governance and redress. And this is one that actually is a point of contention between the EU and the US right now. As many people may have followed in this area, there had been an agreement called the Privacy Shield that allowed data to flow between the EU and the US. And it was just struck down by the European Court of Justice. And one of the grounds is a lack of effective redress for Europeans in the US if their data has been compromised, particularly by US intelligence services, that there may not be standing in US courts to seek redress over how their data is being used. And so there's a feeling that it's very important that consumers be able to redress any harms, usually in a judicial body. And governance involves the creation oftentimes of data protection authorities who can serve a number of functions, obviously investigation and enforcement regarding compliance with laws, but also educating consumers and businesses about their rights and obligations with regard to data protection. So anyway, these are, I think, typical elements. There certainly could be more. And the flip side is you have to also look at a country's capacity to have an agency engaging in all these practices and some of the complexity it may impose on providers. So something you may not always want to have all of these at once. They may be incremental in particular countries, but I think there's some basic rights ultimately to protect customers. So with that, back to Alex.
Thanks so much, David. I think maybe before we jump into the next section, there were just a couple of questions, I think, kind of linking the new paradigms beyond consent to sort of what might work best in practice. And Jerry Grossman from the Bill and Melinda Gates Foundation was asking on your perspective on which of these new paradigms you think would work best, which would be the best approach in the digital financial inclusion context in lower middle income countries. And I know you'll talk a little bit about an example, but just I think maybe in general, which of these do you think could work
Yeah,
best?
yeah, thanks. I think the legitimate purpose one maybe that may be a good match between how easy it is to figure out what's required, but also has the flexibility. As I said before, each company can look at what they do and decide based on that what's appropriate data protection, as opposed to um, uh, having sort of firm laws that you don't build data protection for a company that has a variety of practices. Each company gets to sort of set their own rules based on what they offer. And so I think in the digital context, you can decide again what services you're providing and what data you need to provide those services. And I think that essentially would be the simplest way to go.
Mm-hmm. Mm-hmm. Lynn Exton was asking from Exton and Partners Risk on in terms of auditors that are trained, to assess. I think in the privacy representative framing, are auditors generally trained to assess algorithms and bias? And maybe a add-on would be if they're not, how would you see that capacity building exercise happening?
I guess I'm not familiar with the full scope of auditors, but my sense is that auditors tend to accept what the company tells them about the practices and doesn't sort of get behind. And so I think what would be unique about the privacy representative is they essentially have the legal right to poke into the black box and see how it's working, and take a look at it. I think also one of the challenges we face now are some of the artificial intelligence, machine learning companies are saying, even we don't understand how it works. Even if we know what's going inside the box, we still don't know how it works. All we know is that thousands of variables are considered in real time and then render a decision. And maybe in that situation, other approaches are needed. Maybe sort of what I would like to see is artificial intelligence used to come up with a decision, and then artificial intelligence used to determine if that decision was discriminatory or not. And only if it passes both those tests does it actually get to be used. So I think there has to be some check on it. Again, maybe auditors have that ability, and if not, people with special training to assess algorithms and how they're developed and how they're used would be appropriate. But I think, we shouldn't just trust the machines to make sure that our data is being handled properly, in large part because of historic discrimination. We have racial discrimination that's been systemic in the US and other places. And we don't want to just learn from the past and apply it for the future. It's important that we make sure we're not inadvertently and not unintentionally incorporating the discrimination of the past on a going forward basis.
Mm-hmm. Great. Okay. Last question. Mayada El-Zagbi, the managing director of CFI, was asking how would you see supervisors being able to assess whether a provider is upholding their, a data fiduciary role? What might that assessment or supervision look like?
Well, it's nice hearing from Mayada, former colleague from CGAP. I think in the same way that in the financial context, where there's a fiduciary duty, is to, again, look at what is the consumer's interest in getting the service. And again, is it financial advice? Is it a financial service? And look at what most benefits the consumer and how the data is being used. And in particular, not to have the data used against the consumer, so the consumer gets a less good deal or a less favorable rate. Sometimes consumers who might qualify for a better rate aren't told about it, or for a different type of financial product are not told about that as well. There may be payday lending, which one could raise questions about. But I think you'd want to look at the product or service that the consumer is being offered, and then decide whether that is what type of data usage would most benefit the consumer in that context.
Mm-hmm. Great. Okay. Well, I think maybe we could move on to the final question, which is just, I think a lot of the questions that were coming in were about how to put these paradigms into practice. And so there are a few markets that David could speak to where some of these are being tested. And so maybe you could vote, just press engage, pick the US or India, and we can just see where we go. Looks like India is well ahead. So yeah, so why don't we go ahead and with a little bit of, okay, yep, why don't we go ahead to India and how some of these paradigms are being put into practice.
Okay, go India. This is based on the pending legislation in India, data protection, that was introduced, I guess, late last year, and is undergoing a pretty extensive legislative scrutiny and input on it. But there's a particular section of the legislation that I like, and that is because it really adopts both the legitimate purposes and the fiduciary model, at least in as I read it. So there's language. There are consent provisions in the bill, but again, as I see them, there's a use restrictions that essentially trump the consent. And the use restriction has two components. One is that the information be used in a fair and reasonable manner, and so right there, I think that could arguably be viewed as particularly the fairness component as calling for a fiduciary duty to the user of it. And the second component is what would be reasonably expected that such personal data should be used for, having regard to the purpose and in the context and circumstances in which the personal data was collected, which again, I think reflects the discussion we've had before about the legitimate purposes test. So again, we have fiduciary duty on the fair and reasonable side, and we have a legitimate purposes there. And essentially what India is saying, if this legislation was adopted, is you've got to do both. So it's a particularly strong approach. I did have the opportunity to ask Justice Sri Krishna, who wrote the original report, what this approach meant in terms of a fiduciary duty and reasonableness. And his view was that reasonableness is a topic that the courts are quite familiar implementing and applying. And so again, it's a flexible concept that over time would be fleshed out in terms of how it would govern particular firms. But as a broad concept, again, I think it's one that's flexible, allows for differentiation between small and large, complex and simple firms. But ultimately, both of these would be beneficial to the customer.
And maybe this is just a question for me. So could you talk a little bit about, so it's still sort of in the in Parliament, and sort of how would you see, or how would you anticipate, if, and it seems like when this gets passed, kind of what would be the infrastructure that that the government would need to set up or leverage, and I guess especially for the for the financial sector, or for the sectors that we care about.
Sure. The legislation, again, it's been pending, and there are a lot of unrelated issues that have been somewhat controversial about the legislation, particularly its impact on government's collection and use of data. So I'm not sure. And then obviously the pandemic has made a more complex time to be focusing on legislation. So I don't know if it'll come up in the winter session of the legislature or at some future time. But what the legislation does is proposes the creation of a data protection authority with a huge range of functions. But presumably, ultimately, the data protection authority, and a lot of countries have data commissions or data authorities, would be responsible for enforcing compliance with this provision. Ideally, would be give guidance to industry as to what is expected of them on compliance with these standards, and would also educate consumers about the protections that are available to them. This would largely be governmentally enforced, but I think with hopefully enough guidance to companies that it wouldn't be a gotcha situation, that they would understand what's expected of them. And then maybe some, before cases are brought, some maybe how-to guides about how to comply with this provision.
Great. Well, I think maybe we're getting to cover all of the, possibilities here. Do you think, I think we still have time to maybe address the US, and then I know there are another question or two that would be great to kind of more general from the participants.
Sure. And the US, I have to say, is somewhat cherry-picked example because the US is just beginning now to undergo a debate about comprehensive federal data protection legislation. Up until now, the US has had sectoral legislation for the financial sector, for the health sector, believe it or not, for the video rental sector. And so particularly, again, California, as I mentioned before, it seems to be a driver on this. California's adopted data protection legislation, and there's a push to instead have a one federal standard, and a lot of issues are in play, particularly preemption of state law and also the individual's right to bring suit. But one of the bills, of the many bills that have been introduced in the U.S. Congress by Senator Schatz, would impose a duty of loyalty on providers. And I think this rings very similar to the discussion we've had on fiduciary duty. And so essentially that individual data should be used in ways that benefit, not be used in ways that benefit the provider to the detriment of the end user. Again, with a whole array of bills being introduced, it's hard to know if this approach over others will ultimately be adopted, but I think it's a good start in terms of offering an alternative to consent as a way of protecting data that's being collected and used by providers.
Great. I think we have maybe time for just a couple more questions. There's still a bit of skepticism, I think, about the legitimate use approach, where one of the comments is, how can we kind of question, how can we give any teeth to the legitimate use approach if the companies get to decide what those legitimate uses are? So I wonder if you could respond to that.
Sure. I think what the companies get to decide is not what are the legitimate uses, but what products or services they're offering. It's then up to essentially, ultimately, the enforcer of the law, the government, to decide if those uses are legitimate with regard to the products or services being offered. So I think, again, I don't think the company gets to be the judge of its legitimacy. They get to be the judge of what they get to rather decide what their product or service is. And again, there are some services where it's not reasonable to collect a whole array of background information or lengthy transaction information if it's simply not needed, say, for a cash transaction. On the other hand, there may be situations where credit is being extended, where it's important to gather lots of information about the potential customer to see if they're credit worthy, what their credit history has been with other companies, maybe even to track their experience with this company as well. And so I think there essentially be almost an objective test of is this a legitimate way to handle the data, but it's not the company's decision, it's ultimately the government's decision.
Mm-hmm, mm-hmm. Okay, and a question from Marie Valdez, our colleague at CFI. She's asking, sort of speaking to this, what you're talking about in some of the kind of the omnibus, regulation that looks at all different sectors. But, certain sectors have been grappling with data privacy and other, for in a more comprehensive way, maybe than, let's say, the financial inclusion sector for longer. Are there other industries that you've seen kind of advance in this space beyond beyond consent with new paradigms that the financial inclusion industry might look to as an example?
I would actually look to one in the financial sector as one of my more favorite examples, and that is credit bureau regulation. I was responsible for enforcing the laws against credit bureaus for about 10 years at the U.S. Federal Trade Commission. And the U.S. has a law from 1970, believe it or not, the Fair Credit Reporting Act,
Mm-hmm.
that largely does not uh, base itself on consent. And that makes sense because if you only consented to be in a credit bureau or not, people with bad credit would just not consent, and the credit bureau would only have people with good credit, and wouldn't be very helpful evaluating applications across the board. And so the credit bureau model doesn't turn on consent for the most part. There are some exceptions, but for the most part, and instead has compensating rights on the back end, similar to what we've been discussing, which is credit bureaus in the US can only give out your credit information for a permissible purpose, which could be quite similar to a legitimate purpose. Um, Individuals have access to their data and have a right to dispute it. The data can only be reported if it's negative, from 7 years. So you get a fresh start with data. There's enforcement mechanisms, there are security mechanisms in place. And so there's a whole array of rights, but consent is really not central, both in the US and credit reporting laws around the world. Is not central to the way the system operates. And yet it's also a law that has been flexible. It works for all kinds of databases, not just credit databases, but insurance, employment, landlord-tenant, gambling, cell phone, all kinds of databases. And I think that's actually a shortcoming of some of the U.S. Health privacy law. Is it's not really a database law. It's sort of a binary one-to-one relationship between a doctor and, say, a provider. But we live in a world now where there are multiple providers, insurance companies, entities in the picture. And I think looking at a database transactional relationship makes a lot more sense. And I think that is one advantage of the credit reporting laws, is they essentially, even though they were from 1970, do take into account how databases and networks operate.
Wow, that's really interesting. I guess maybe one last question. You mentioned at the outset, one of the shortfalls of the consent model is just how binary it is, and how you either consent to this and you get the service, or you don't, and you are excluded. Have you seen any examples of companies or providers experimenting with more choice, more options, in terms of what consumers can sign up for as it relates to the data about them that's being collected?
I can't say sort of I've done a careful survey. I think there are companies who try to offer more of a menu of choices. But I would go back, I guess, to the threshold issue, which is people don't read privacy notices. And if they read them, they wouldn't understand them because of the complexity and the legalisms. So even if there are sometimes there are choices embedded, I don't think there's much evidence that people want to spend the time on privacy notices. They just want to have some confidence that their information is protected. Now, again, there may be contextual notices, like on cell phones ask you if you want your location used, where you're getting a specific choice or set of choices. And I think those could potentially be effective, but even those are only really asking a limited question. There may be other uses of that information regarding location that are not disclosed in the simple notice of, do you want to allow location tracking now for this app, for this this time you're using the app. But it doesn't talk about how that location information will be used, who will be shared with, how long it'll be kept. So even that seemingly simple choice that you're being given, actually underneath is a much more complex choice. And again, having some protections would be critical. But so I think, so the answer is, I think there's some efforts on it, but I don't think it goes far enough.
Great. Well, I think we're almost at time. And I think, I was just thinking, like, so many of these paradigms are being tested and rolled out. I almost want to send a calendar invite for Financial Inclusion Week 2021, like a year from now, just to check in and see, how these different frameworks are being tested and rolled out in other markets, because so many places are grappling with these questions. And so, yeah, just a lot of really great information and insights. Thank you so much, David, for your time and sharing this great work with us. And thanks to the audience for their wonderful questions. And I'm glad we got through all the different adventures, so to speak, all the different slides. So everything was covered. So thank you so much. And please, continue to participate in Financial Inclusion Week. We'll post a link to David's paper on this webinar, and there'll be a recording shared of this. So thank you so much, and have a great rest of the week.
Thanks a lot.
Okay, take care.